All right, it is 11:45, so let's begin. My name is Cece Schnupp, and I am chair of the Bench and Bar Committee. I'm delighted to welcome you here today for our presentation. Before I begin, a big thanks to our IT team for getting everything up and going so that we can have this presentation available here today. On the phone and also on the court's website after. The program materials and the presentation will be available on the Bench and Bar Committee webpage. Also, all past programs are available there. It's a great resource should you have any questions and want to share this wonderful information. Thank you also to the many judges who are here with us today. We appreciate your support of these programs and for taking time during your lunch to come and join us. And thank you to all of you who have come today. I will be excited to introduce you to our speakers in a moment. Before I do so, they have said that they welcome questions as they come, so don't be shy. Please feel free to pipe up should anything come as we go. So without further ado, I would like to introduce you to our panelists. So first, to my left, I have LaDonya Horton. She is a sole practitioner with a focus on family law. She is also a Special Assistant Attorney General who represents the Division of Child Support Services in DeKalb County. She represents the state agency to establish and enforce child support obligations. Previously, she was DeKalb County Assistant Solicitor and an Assistant DA for DeKalb County, establishing and enforcing interstate child support obligations. She earned her BA from Spelman College and her JD from the University of Illinois College of Law. To her left, we have Shayna Steinfeld. She is a shareholder of Steinfeld & Steinfeld PC and practices with her husband, Bruce, a fellow of the American Academy of Matrimonial Lawyers. She is the past president of several organizations, including the Atlanta Bar, the Georgia Association of Women Lawyers, the Our Georgia Network, of which she helped found, and past chair of the sole practitioner small firm section of the Atlanta Bar and bankruptcy sections of both the Atlanta Bar and the State Bar of Georgia. She is actively involved in the ABA and various sections there as well, and regularly named a Georgia super lawyer. She is a graduate of Emory, where she received her JD as well as her BA and MBA, and she frequently lectures and authors many publications, including The Family Lawyer's Guide to Bankruptcy, which is published by the ABA Family Law section and is in its 4th edition. And finally, we have Ian Falker, an attorney with more than 25 years of legal experience. He practices on complex bankruptcy matters involving intertwined corporate and personal debt situations. He also handles family law and small business matters. He received his Bachelor of Science from Tufts University and his JD from Albany Law School. He has also served as the president of several organizations, including the bankruptcy section and solo and small firm sections of the Cobb County Bar. And he is a member of the family law section of the Cobb County Bar, NACBA, and MACBAG. He also maintains a bankruptcy blog, Bankruptcy Beyond the Basics, and is a regular speaker on our very topic, the intersection of bankruptcy and family law. So without further ado, I welcome our panelists.
Thanks for everybody for coming. When we pulled into the parking lot, we weren't sure there's going to be anybody here, so we're glad to see faces in the room and some on the phone. Somebody pointed out I may have hit the bar a little too high. Everything you need to know about bankruptcy and family law, I probably should change that to a few things you should know. So thank you, Carol, will point that out. We're going to try to do this as a joint presentation and just chime in. If you guys have questions as we're doing this, please speak up, because whatever you want to know is what we want to talk about.
Okay.
Right. All right, could you hit the next slide for us? Or not.
Or not?
It's wrong with the paper.
Next slide.
Oop, there we go.
All right. So divorce is different from bankruptcy. There are different issues. Your divorce court's dealing with equity. There are different forms. There's a domestic relations financial affidavit. There's a child support worksheet. There's a settlement agreement and orders and other things. And even though the term equity, we throw around a lot in bankruptcy court, in the divorce court, they're handling it differently. And
Yeah, that's one of the things I hate to say this, but when I describe the difference between the bankruptcy court equity and the family law equity, I say that the bankruptcy court has a fairly cold heart and the divorce court has a fairly warm heart. And that just seems to be the way it is. I think the issues are more straightforward in the bankruptcy court, at least most of them, not all of them.
Well, I think bankruptcy court, we're interested more here with dealing with protecting creditors. And the ex-spouse is more one of the creditors, and there are other creditors' interests that come into play. And in Superior Court, the creditors come into play, but the primary purpose is dividing things between the two spouses, and it's a scale.
And you get into that ugly, he said, she said, what did they do 20 years ago? He charged this on the credit card kind of stuff. Now let's go. We can go to the next slide.
Next slide.
All right, so forms. If you've got somebody who recently was divorced or is in the process of divorce, please, 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 please get the forms. Go to the websites, whatever you need to do, call their family law lawyer. If you've never seen a domestic relations financial affidavit, some of them call it a DERFA. To some extent, it's a fantasy document. It's filed at the beginning of the domestic case. In fact, by law, it's supposed to be filed when you file your case, which is amazing how you're supposed to know what's going on when you just start the case, but that's the requirement. So sometimes you'll see them to say to be determined or zeros or question marks in the forms. So very often there's not a lot of information in the forms, and it's also at the greatest point of change. Nonetheless, you need to be aware that this is basically the income and expenses of the divorce court. So this is Schedule I and Schedule J to us. Go through these forms and see what they say. Make sure that the expenses match up to what you're claiming. And if they don't match up, that's fine. Make sure you have a good explanation of why there's a change.
Also, if there's a prenup or postnup, or sometimes it's called an antenup, there are documents that are financial disclosure documents that come into play in the divorce case. So if those documents exist, these are all financial documents that take place under seal that are verified in the divorce process, that an ex-spouse, if you're representing the debtor in the bankruptcy case, the ex-spouse is going to be there waving at the trustee that as debtor's counsel, you need to know what's there so your disclosures are consistent. And you need to be able to compare the documents to make sure there's consistency. And the ex-spouse has the most information on your client, and the client's going to be there telling the trustee what that person knows about your case. So you ought to find out what is going to come out from the ex-spouse.
Next slide, good. Another form that you'll see is the child support worksheet. Again, another document that's supposed to be filed at the beginning of the divorce case, long before discovery has started, long before anybody knows what's going on in the divorce case. Everybody's supposed to know what's going on, but it certainly has to be filed at the end of the case. And again, it also shows the gross income and certain expenses. It may reflect child care or something that you'll often see in there. Again, just another place to look to make sure your documents are consistent. If somebody's going to come in and create problems and you didn't look at these forms, you're going to get caught off guard. So this is something you should be looking at.
One of the things we didn't put in here, because to us I think it seems so obvious, but I'll throw this out here just to make sure it's covered, is the divorce decree itself. You want to make sure that you look at the divorce decree itself and make sure that whatever obligations are within it and contained within it. And it may be that it's 15 years old and a lot's changed, and it may be that it's hot off the press and barely been entered, but you need to look at that and make sure that you've got those items covered. And
it's amazing, we all know that clients do not always tell us the truth. and that's being kind. The person who comes in with a ring and talks to you, and you explain how they can't go forward unless they're prepared to lose the ring, and of course then they go to somebody else down the street and mysteriously that ring is no longer in existence. The divorce decree has all kinds of transfers in it that were supposed to happen, some of which may have happened, some of which are not yet due, so they may be assets. You just need to be aware of it. Right.
And then a lot of these documents, too, we're talking about this in the context of the divorce and at the time of the divorce and during the divorce, but a lot of these also come up in terms of a modification or a pending contempt case. So these are relevant at various points in time when you're dealing with conflicts between parties who have been or about to become, or, within a fight between two parties that used to be married or have children together, even if they were never married.
All right, so if you've never done any family law cases, and God bless you, those of you who have not, it's a special type of client is all I can tell you at times. To give you an idea of some of the basics, child support is pretty formulaic, okay? Or at least it starts out that way. It's what we call a blended income approach. And here's the thing that you have to be aware of. You're taking into account all of the income, but it's not necessarily real income. Sometimes it's the potential income. So we always joke around in my office, we try to pick equally on husbands and wives. Husband used to make $250,000 a year, and he says, screw her, I'm going to flip burgers at McDonald's. And the court says, that's lovely, you can flip burgers till your heart's content, but we're going to base everything as if you're making $250,000 a year. So sometimes you'll see numbers in the child support calculations that don't reflect actual income. You need to be aware of that. It basically calculates both parents' income, looks on a chart, and figures out what the basic child support is to raise certain kids at a certain level, and then does some calculations that change from there. Alimony is not formulaic at all. So if you're looking for some reason why that was there, it's not because you looked in the statute and said, oh, you do this. It's based on the needs of the recipient and the ability of the payor. So that's one of the things you should kind of keep in the back of your head. If somebody's paying alimony, they probably had the ability, at least at some point, to pay that. Circumstances do change. You can modify certain types of alimony. And property division, we talked about the equities in the Superior Court and the divorce court. And that's based on how they treated each other. I always tell my clients, we deal with equitable division in Georgia. I did not say equal. I have never said equal. I give my speech the exact same way every single time. So when somebody says, no, you said equal, I can say, no, this is how I give the speech every single time. So it's how they treated each other, what they did during divorce. So it's not the same things that we're dealing with. And you want to talk a little bit of advice that sometimes you give people and when to file?
Oh, you know what? A lot of times people call and they want to know whether they should file bankruptcy first. Or, I want to file bankruptcy. I got a call a couple of, not so long ago, and the guy didn't want to, this gentleman didn't want to go through the discovery process in the divorce. And he thought he was going to avoid, he could avoid discovery by filing bankruptcy. So he was going to file bankruptcy, and that way his wife wasn't going to see what he had in the divorce process. And, I talked him off that ledge and told him, the bankruptcy case is, kind of a, Judge Bonnefeld used this expression with a Chapter 11 debtor a very long time ago, and the expression was financial underwear on display. And I thought that was a very descriptive, accurate way of describing things, and I've used that. Sometimes I don't attribute it to him. But it's true. You file bankruptcy, and it's a financial disclosure process. And your finances are out there, and it's public record. And, if this guy thought he was going to file bankruptcy and avoid giving discovery to his wife as to their finances, he was mistaken. And if somebody wanted to tell him otherwise, they were mistaken. This was a financial disclosure process, and that wasn't going to be an effective litigation tool. Now, there are other things he might accomplish. There are things you can accomplish by filing bankruptcy first, and we've got an ethics slide coming up towards the end on this. If the two parties have lots and lots and lots and lots of debt and no assets, filing bankruptcy together before the divorce may be a good mechanism to clear the debt and just deal with freeing up money to address child support, maybe alimony, but it's a good way to clear the decks. Not a good way to avoid disclosure, but it's a good way to clear the decks. I personally, and Ian and I have discussed this over the years that we've done this together. I don't like doing the bankruptcy first. I think you've got a lot of open variables, and you don't know all your variables if you do the bankruptcy first. I'd rather see the divorce go first, know what all your variables are, not have a springing debt. I had a meeting with a client a week or two ago, and the wife filed bankruptcy back in 2012, and she discharged a whole bunch of business debt. Well, the business debt's still a marital debt, so in the context of a divorce 5 years later or 6 years later, he's still obligated on that business debt. So if he now settles the business debt, that should still arguably be a debt for the divorce purposes of the divorce as far as dividing what's his and hers. And that kind of springs back. It's not that you're making her pay it per se, but as far as marital equity goes in this equitable analysis, there's a charge against the marital estate because he's now still liable on that debt, and that comes into the assessment. So I like the divorce to come first because you see what all your variables are. So they're different variables that come into play on all this. I'm sorry I'm using variables so much, but there's so many things that you have to consider in representing the parties. And if there's a lot of assets and there's a lot of debt, this was a multi-million-dollar estate, and you got $8 million of assets and you got $6 million of debt, and you got a bankruptcy from a few years ago. There's a lot at play, and you got to analyze it and figure it out.
Now, talking about if both cases are kind of being contemplated, there are times where I'll tell a client, don't fight over what's going on. So sometimes that child support obligation is coming up, or the ex-spouse wants alimony. Now, obviously, I'm not suggesting somebody commit fraud. We're not going to that extreme. But there are certain fights that make sense and certain fights that don't. So there have been clients where we're sitting there and we're doing the calculations, can they qualify for Chapter 7 under the means test? And the answer is, well, maybe if they had a child support obligation of such and such, or an alimony obligation of such and such, maybe they do qualify. So maybe it makes more sense at that point to not fight in the divorce case and take advantage of that in the bankruptcy case. And again, I'm not suggesting you create something that doesn't exist, but you don't fight over $100 when it's to your benefit.
I mean, and there'd be a legitimate basis
Right.
to pay child support or alimony, but it might be the difference between, a $300 child support obligation and a $200 child support
Right.
obligation.
And if that's the difference of getting rid of $100,000 of unsecured debt in bankruptcy, that's probably a pretty good deal for somebody. The other thing that you mentioned, and I've seen this a couple of times. Let's say that husband has $100,000 of unsecured debt and wife has $100,000 of unsecured debt, separate in their own names. Wife files bankruptcy 6 months before the divorce. Now they're going in front of the divorce court. Does the divorce court look at that as, oh, well, there was $100,000 and she got rid of her $100,000 and now he takes his $100,000? Or do they discount the first $100,000 and say, now there's $100,000, split it up 50-50?
Well, that's why I like the divorce to come first. That's what I'm talking about, having too many variables if you do the bankruptcy first.
And I've seen the divorce courts do it both ways, by the way. So no particular rhyme or reason as far as I'm
Because
concerned.
that's the springing debt.
Right.
Because all of a sudden your back said, well, she got rid of it. She doesn't have that debt anymore. So now she's got more income, or he's got more income to pay and contribute towards the $50,000 that's left on his debt, and she can't file bankruptcy now again for another 8 years, or then she has to do the Chapter 13, but the debt's not in her name, and this is something that clients never understand. I mean, we get it as bankruptcy lawyers, but divorcing debtors, and I try to lecture divorce lawyers on this all the time, they don't understand that, and you sit there until you're blue in the face. The divorce decree, this is a contract between the husband and the wife. The divorce decree, contract husband and wife. American Express isn't a party to the divorce decree. So if the husband is going to pay American Express it's an indemnity, and you have to, be careful about your indemnity language.
Right.
But American Express can't, that they're not bound by that divorce decree, and the clients just don't understand this. They think if the divorce decree says he's going to pay American Express, she doesn't have to worry about it anymore, even though American Express gets to look to her. And this is something that the normal people who aren't bankruptcy lawyers, like even a lot of divorce lawyers, they just don't understand that. And that's something you out there, peers, I'm talking to you, can help educate people about the fact that divorce decrees are contracts just between those two parties, and the creditors aren't bound by that. And that means in your case, you can file claims or help get claims filed that might come back to haunt your client, because those indemnities, we'll get into this a little bit, on the discharge issue, they may be surprised because it springs back.
Next slide, good.
Next.
Want to talk about the automatic stay?
Automatic stay. So there are exceptions to the automatic stay on divorce issues. So when does it apply? The automatic stay is automatic, although, I had a case in the fall and we argued about what about the automatic stay is and isn't automatic. It's supposed to be automatic. It says automatic. We know it's an automatic stay. What does it stop? Does it continue, commence? It's supposed to be automatic. We're bankruptcy lawyers. We expect that it arises on filing and it's automatic. In my summary on the divorce child support front is it's automatic as to everything except that there are exceptions that apply to pretty much everything in the child support domestic front, except if you're going after things that apply to property of the estate. So if you're going against property of the estate, the thing comes, how do you decide if you're going against property of the estate? And then are you brave enough to risk the wrath of the bankruptcy court if you get it wrong? And that's when I come in and I say, well, I'm super conservative. I don't want to risk the wrath of the bankruptcy court. And there's a case called In re Rollins it was a Judge Brizendine case going back a while ago. It went up to the 11th Circuit. And ultimately, it was deemed that the Cobb abandonment action against the debtor really was a criminal action and wasn't a collections action, and the stay, an exception applied, but it probably cost them tens of thousands of dollars and took a long time to get there. There are exceptions, a lot of exceptions that apply in the domestic arena, but it's really simple to get the stay lifted if you want to go forward. So I respect the stay.
Yeah, easiest thing is to come in and ask for relief from stay, and that's probably the simplest thing to do. And then, of course, watch out for the co-debtor stay in Chapter 13 is the biggest issue. All right, next slide, we'll start talking about some of the exceptions. Nope, next slide, no.
Next slide.
There it is.
Okay.
All right. I was sitting in Cobb County one day and I was talking to some of the judges, and I asked them, would it be helpful if I gave a seminar on the bankruptcy divorce crossover? And one of the judges looked at me and said, not to me. I said, okay, why not? She said, because if I hear the word bankruptcy, I'm done. I just stop everything. And we know that's not the rule, but that is to some extent their default position. And I think it's also to some extent the bankruptcy judge's position on domestic issues. I'm not touching it. I don't want to know about it. Judge Brizendine was great. He said, I don't care what it is. It's not mine. That much he knew. So that was fantastic. You want to talk about some of these? Obviously, a lot of these you know, but here are some of the exceptions. The establishment or modification of an order for domestic support obligations. So when they're going for that child support, that first order, the temporary hearing, and then you have the weird circumstance, and this happens all the time in the family court. And it's usually the husband who's the payor, but not always. He's being hit with a contempt action because he hasn't paid his child support. At the same time, maybe very legitimately, he needs a modification because he's lost his job 2 years ago, and now he's only making 2/3 of what he was making. Both cases are pending. He files bankruptcy. Well, we know they can't go forward with the contempt action, but he can go forward with the modification. Good luck getting one of the divorce courts to let you do that. You can, and I've seen it, but it's just not something they're comfortable with. They usually will just say, hands off on everything.
And as I said, I had this experience in Cobb recently where the judge was going forward anyway, and we had to stop it. So not everybody does the same thing.
Oh, yeah, there was a great opinion. Was this the was that Judge Green's?
Judge Green,
Judge,
yeah.
okay, Judge Green in Cobb County. It's within the last year or so.
Yeah, I mean, very recently.
Basically, had a wonderful chance to explain why he was going forward, and I believe the entire explanation was, having considered the matter, the court believes the stay does not apply. I think that was it. Okay.
And, and I've been told, and maybe the judges want to chime in, but I mean, and I tell them that, if there's an issue and you think one of the exceptions apply and you're in Superior Court, encourage the Superior Court judges to pick up the phone and call, or vice versa. That the judges can communicate with each other. The exceptions are there. Instead, as the attorney, I don't want to risk calling it wrong.
Right. And we talk about assets that are not property of the state. Obviously, this is something that's more applicable under Chapter 7. Here's something that I'm waiting for, and I don't know if you've had this case yet. It's pretty clear that an IRA, at least in the state of Georgia, is not an asset. It's not property of the bankruptcy estate. Okay? So what do you do if a high net worth debtor files Chapter 7, he owes a tremendous amount of back child support or property division? Could you go forward against that non-estate asset in the Chapter 7? And I think the answer is yes. I would feel much more comfortable representing the prosecuting party to get stay relief before I did it, just to be safe.
I'm just so reluctant to make any assumptions. You get into trouble when you're assuming things. I mean, I even have been running into the issue where the debtor has a discharge in a 7 and the estate's still open for assets.
Right.
And then you're in this quandary because the discharge injunction replaces the automatic stay. So there is no longer an automatic stay. And I've got a client with a non-dischargeable debt. And, okay, post-petition income's fair game, but in a couple of these cases, the income's minimal. And then unless you've got a clear abandonment order, the trustee's still looking at assets. And some of these trustees can be looking at assets for a really long time. So what do you do with this gray zone? And I don't have a good answer. I mean, there is no good answer,
Yeah, I mean, you can file a motion to compel the trustee to abandon, and that'll give you an answer, but you got to go through the process.
Is that going to be a good answer? If he's still looking at assets, he's still looking at assets. My client can be given the right to go after the assets that the trustee is still looking at. I don't think so.
Right. And of course, if they're valuable, the trustee's usually not going to do anything. So,
I mean, it's a really interesting overlay question.
And it's one that causes that's the area that I think causes the most delay in the bankruptcy and divorce. Where we've got a couple of judges in the room, right? You don't want to touch it at that point. And neither does the divorce court. So I think the case just sits.
This case just sits, and the client doesn't understand, and the client's mad at you, and you just don't have good answers.
Right. And we're used to a certain pace in the bankruptcy court, which is pretty fast by comparison. I once had Judge Brizendine, after he granted relief from stay, for us to go back to divorce court to get something resolved. 45 days later, we were back in front of him for status conference. He said, "So where are we?" The divorce attorney's looking and going, waiting for a court date, maybe? 6 months down the road. Not 6 months, but 2 months, 3 months down the road? That's not an uncommon situation in the divorce court. Our next slide, please.
So.
Anya, this is going to be easy.
Yes.
You're up.
So, fortunately, the child support agency, we're limited to just the child support issues and none of the other property or debt issues. Also, what we're charged with is establishing child supporters, not just for people who were married, but people who are still married but are separated. For whatever reason, they have not filed a divorce. So there is no question about, the property, they're still their property. So unfortunately, the law only lets us look at the child support issues. So sometimes people will come in, though, with a divorce decree or legitimation or something that's already ordered child support. We can enforce that, and we become interested when that debtor or that non-custodial parent has filed bankruptcy. Also, some people don't know this, the child support agency also enforces alimony debt. but only alimony that's based in support, not as a division of property. And also, they still have to have a minor child who's entitled to child support. So if there's some past due alimony owed, we can deal with that in the context of a bankruptcy. So you'll see the agency as opposed to the other parent sometimes when the child support case is filed. And when there's, like I said, when there's people have never been married or still are married, you'll probably be dealing with the agency as opposed to that other creditor or to that creditor custodial parent. You can change to the next slide. And bankruptcy law, as you all know, I'm sure, has given certain exceptions to the automatic stay, and the agency is very aware of that because we issue income deduction orders, or what we call federal income withholding. That means the court doesn't have to sign off on it. If we find out somebody's working somewhere, we send the income deduction order, and we're comfortable that that's an exception to the automatic stay. We also can suspend state licenses. That includes your bar license. We can report exactly. We can.
That's news to me. That's make sure certain clients are aware of that.
I have suspended medical license before, so yes. We intercept state and federal tax refunds, as well as if a parent is obligated to provide medical insurance, that can still be enforced. That's specifically listed as an exception to the automatic stay. You can go to the next slide. And of course, there's always exceptions to the exception. As child support attorneys, we are not bankruptcy attorneys, and so we go to training annually, and we follow more the conservative side. The state does not want to get in trouble and be hauled into bankruptcy court for violating any stay. So we were happy when the bankruptcy laws were changed and listed these specific exceptions. However, when case law came later, they kind of clarified that a debtor can put into their Chapter 13 plan that the state is not allowed to do those enumerated exceptions. So if it becomes part of a confirmed plan and it's not specifically stated in there that the debtor is okay with the agency suspending his license, we'll probably be violating the confirmed plan. We may not be violating the automatic stay, but we can violate the confirmed plan and still be in trouble, and the state does not want to get in trouble. So we will sometimes we will litigate and try to say, well, hey, especially if the person's really far behind on their child support, we like to make ourselves known. Well, look, hey, there's this child support case here. We would like to enforce this since there's no payments being made. But, and you can go to the next slide, fortunately, it's still going to be a non-dischargeable debt. They can put whatever they want in the plan, but at the end of the day, after the bankruptcy is discharged, we can still enforce our debt. It's still going to be a non-dischargeable debt. I think the child support agency offers a lot of some benefits to both a debtor who is a non-custodial parent debtor who owes past due child support, which was mentioned earlier. We can still do modification actions. And if a person comes to us and it's clear that they filed Chapter 13 in good faith and they're behind on their child support, this might be an advantageous time for them to ask for the modification. We're not afraid to go to Superior Court on it. We are pretty confident that that's an exception to the stay, and we actually have an administrative review that we can take initially. At least if the order is 36 months old, we can review it, and if true enough the financial condition of this parent has changed and we do our child support worksheets and it ends up being a different or a decreased child support amount that could benefit this debtor by reducing their child support, which is going to be in the best interest of this child in the long run, because that's what we're not representing either parent. We're making sure this child's going to be taken care of now and in the future. So if it's best at this time to reduce this person's child support payment to ensure that they're going to keep a job or keep their driver's license or keep their ability to work now and in the future, that's going to be in the best interest of this child. So we're going to work with that debtor, with the debt. I've seen a couple of bankruptcy attorneys that I talked to or emailed with, but have never seen face to face. So I'm happy for this opportunity. So because I like to communicate and see what's going to be in this child's best interest. And then on the flip side, if a custodial parent who is a creditor who is owed some child support, we will serve as a place where notices go. Unfortunately, sometimes non-custodial parents aren't aware of how to contact the custodial parent. But if they contact the agency, we'll definitely make sure that she or he is aware that the debtor has filed, the non-custodial parent has filed bankruptcy, we'll receive those notices, we'll review the plan, and if we find that the plan is not filed in good faith, we will do what we have to do. We hate coming to bankruptcy court, again, because we are not bankruptcy attorneys. But if it means that we need to file a motion for relief of stay or file a motion to dismiss the bankruptcy because it wasn't filed in good faith, or there's just no substantial payments being made on the child support obligation, the child is suffering, we'll definitely do what we have to do. We'll review the bankruptcy plan, determine if there's assets, and we can send an income deduction order, and we can also be that confirmation to the trustee whether or not the domestic support order has been complied with, because that is, from my understanding, a requirement. In order to get discharged, you have to have state and verify to the trustee that you are in compliance with your domestic support obligations, and some people are not. And if we let the bankruptcy court know that, that might compel them to become current on their child support, meaning, because that could mean a discharge or not a discharge of their bankruptcy.
We'll talk about some of the 11th Circuit cases.
These 3 cases that are on the screen, just you might want to take a look at them. There's the overlay. I had a case with Judge Ellis Monroe a couple of years ago. It was a Chapter 11, and I was representing a client with a divorce alimony claim, and we got into an issue. Leon Jones and I got into this issue over the plan injunction, just under the Chapter 11 plan, and whether the debt was discharged or not. And we got into this overlay between the plan injunction versus the discharge injunction. And these cases really get into, can you collect a discharged debt, and that overlay with the plan injunction. And just, the 11th Circuit says the debt's not discharged. The debt still survives discharge under 523, but there may indeed be a plan injunction, and you can't violate the plan. So you may have to wait out the plan, and that plan may control, and then there's case law about the plan controlling. And, like what LaDanya was saying about, you can't violate the plan. So these are cases that are worth looking at and noting down and going back and reading. So that's what those are there for.
And LaDanya, you were telling us before we got started about how long some of these cases can drag on, and tell them about how old some of these people are when you're getting collections.
We sometimes have the problem where the child is now an adult who has children himself, but his parent is still owing child support to their custodial parents. So these cases can last forever. As long as the person has opened up the case while the child is a minor, we'll continue to enforce the case until every penny is paid through bankruptcy and out of bankruptcy.
And one of the aspects to this, too, is that the clients need to maybe try to modify the child support, and they think they have a deal worked out with their ex-spouse, or they think they know better than the attorneys, and they don't go back to Superior Court and modify, and they accrue these obligations even though they can't pay them, and then they think bankruptcy is going to work something out for them, and they just can't deal with it. So they wind up with these huge obligations that they just can't get out from under. And part of the problem was they didn't try to modify when things first started going south a really long time ago. Different from a property settlement, which is non-modifiable.
Next slide. I think that's yours too.
I think I've already talked.
You
This is
that?
mainly the benefits that the agency would offer for both debtors as well as creditors who's owed child support and who owes the child support. We'll, like I said, we'll file proofs of claim, go file the motions for relief, but generally what we're going to do is figure out what's in the best interest of maintaining the ability of this parent to pay a consistent amount of child support. And a lot of times I'll get a request from bankruptcy attorneys, hey, the amount of child support that this person owes is not going to let him get this plan confirmed. Can you agree to pay it outside of the plan? And if it's in that child's best interest, I'll write that up, says yes, and we can continue to, as long as you put that in the bankruptcy, if you put that in your confirmed plan, we'll be happy to do that. If that's going to let him or her successfully complete the bankruptcy, if that's going to put him in a better financial position at the end to consistently pay child support for their child. So frequently I'll file a proof of claim if I need to, but if I can get those arrears paid outside the plan, we'll do that as well. But we just ask that it be in the confirmed plan so that we don't get accused of violating the stay or a confirmed plan.
I have a question with that. Glad you brought that up. Because I've had cases in the past where that's kind of the stopping point that kind of holds everything up. We have a situation where the debtor is coming out of their paycheck, and it may be for arrears and ongoing. So that's the first confusion. How much of it is arrears? How much of it is actually for ongoing? So say we can even get that figured out, and it's probably, I think I may have even called you about this before. What happens? How do we actually get some type of documentation? Is it possible to get documentation from the child support agency if it is a situation where you will agree to, because it is in the best interest of the child, or either because of the amount or what have you, to continue the deductions from the paycheck rather than to be paid through the bankruptcy? Because I think a lot of times what we see happens, the child support agency may not file a claim. We know they owe, we have it in the plan, but because it's still coming out of their paycheck and they haven't changed that, we're kind of stuck. We want the arrears paid through the plan, but because no claim has been filed, that won't happen. And the trustees are asking to get some documentation from the agency that they will agree or they will prefer to be paid directly the way it's been paid through the paycheck. But we can't get the documentation. I've had cases to actually fail because we could never get any documentation from the child support agency. So is it something the debtors' attorneys can do for our clients to facilitate that? I know we can't call, because I've had to explain to my client, you're going to have to call. Can you go down there? Well, no, that's in Cleveland somewhere, you know. Mm-hmm. They can't literally get to whoever they need to get to. Is it something, some type of form, document or something that could be used or could be created?
Well, first of all, the way you can determine what's for current support and what's for the arrears, like they said at the beginning, look at the pleadings. Look, in our case, since we have very limited discovery, it would just look at the final child support order or the divorce decree, and that way you'll be able to tell what portion of that's coming out of the check is for current support and what's for the arrears. Now, as far as getting in touch with someone, this is a huge agency that has several attorneys and several cases. If you direct your client, they don't have to go to the office where the order was entered, because a lot of people are transient. So, but there is a child support agency in every county of the state. They can go, if their order is in Fulton County, they can go somewhere in Brunswick and get any documents that they need for their case. So they can go to their local office. I'll be happy to share my email and I can try to figure that out. But as far as what would be easiest is if you put in your plan, if you want your client to continue to pay the current and the arrears through the plan, if it's in the plan, that's all that the child support attorneys look, because we're trying to get as less heat as we can and have to go to bankruptcy court as few times as possible. And we're comfortable if it's in your plan, and that's the first thing I look for. How did this debtor propose to treat the child support? If they says we are okay with this paying outside the plan, we're going to code it on our case. We have a way to code it on our computer so that the income deduction order continues. Now, what's supposed to happen is once we receive that first notice of bankruptcy, they're supposed to amend the income withholding for current support only and to file the proof of claim if that language isn't there. So that's what's supposed to happen. If that's not happening, your client can contact us, and that would be an escalated position because, again, we're afraid of the bankruptcy court. So if they make enough stink about it, it will change, and then that will force the attorney to file the proof of claim so that the debt is dealt with.
And effective January 1, the state court system went to online filings. Now, that may not help you get stuff behind, but at least going forward, you should be able to see, I'm not going to say everything. You certainly can't see the DERFAs, but you can see quite a bit of stuff.
The problem with what you're stating is for the trustees is that the code provides that those claims have to be paid in full unless the child support agency consents. So if we don't see a consent from the child support, I mean, we don't know that you always consent to that. So that's the problem that we get between the debtor's attorney and the trustee of us recommending confirmation is that if they don't have an actual consent from the child support creditor saying that we consent to this treatment of not being paid in full in the plan, then we don't see how we can recommend confirmation because their plan's not in compliance with the code. And that's the rub, I think, that we have.
Yeah, and I think the problem of that is twofold. One, getting that case that's an issue known to the right person, because the attorneys, we go to training to know that we're going to look at this a case by case position. If it's in that child's best interest that we agree that 100% of it's not going to be paid through the bankruptcy and we get the rest of it after the bankruptcy, that's probably what we're going to do, because a lot of the times, like I said, we've got kids who are grown and grandparents that we're still trying to get money from. So if we can get something, we more than likely would agree to that. So the problem is getting that information known to the right person.
Right. I think that's the dilemma, though, is how do we do that? Because I do know that we've seen cases that the debtor's attorneys have felt like they have to, not oppose dismissal of the case because they cannot get anything from the child support. And I know we've presented the case to the judges a few times, and the judges have said, if we don't have consent, and I can't speak that all the judges would rule the same way, but I know that it's a dilemma. We all feel like we're caught in a catch-22 because we want to be in compliance and we want to support child support, but we don't know. Is there something that maybe we could work out?
It's very possible. We have our attorneys conference actually in a few weeks. And we do have a master list that's shared internally of all the attorneys all throughout the state that represent the agency. And I'll be happy to ask them if it's okay if I share this with someone who you can put it on your website or have access to. Because I can't tell you, I get pleadings from every county and I have to farm it out. But I'd be happy to share that list. I just need to get confirmation from the AG's office that I can do that.
We have a question online. Let me see if I can activate the phone.
To place all participants are now in listen-only mode. To place all participants are now in listen-only mode.
All right, while he's doing that, I want
place all participants in broadcast
point out
mode,
two things.
press 1 to begin a voting and polling session.
Rule
press
3004
3.
allows
All
the debtor to file a
participants
claim.
Are now in listen-only mode.
So if the claim doesn't come in, you can file the claim on behalf of the creditor. In situations of non-discharge or where it's critical that the claim gets filed, you can file the claim. And then also, maybe there's a way to work around it by treating it as long-term debt. But I'm just throwing that out there.
But you can't do that unless the creditor the child support, the domestic support obligation.
You still have the creditor consent, yeah.
And I think
Okay.
that's the problem, is the whole consent piece. I think there's nothing in place.
Okay, so
Thank you for explaining, because that does give me some insight. I actually wasn't aware that if you all see it in the plan, you're done. You're good. What we're stuck with is you're done and you're good, but I can't provide to the trustee that you're done and you're good.
But you could reach out with a consent order to get the consent.
Sometimes we can't.
Right, you can't get a response.
Communication.
Okay,
And so
all right.
that's the problem. That's why I have my debtor going crazy trying to find
Right.
a way to communicate and get something in writing. And I keep telling, can you get something in writing?
Yes.
An email or something.
I think, pretty sure, that at least once, or maybe more than once, in this sort of circumstance, where a response was necessary either from an actual DSO holder or from an agency, that I've issued a specific order and notice to those parties saying that basically, if we don't hear back from you, we're going to determine that you have consented to this treatment.
Okay, so that's,
Repeat that so the callers could hear.
So Judge Bezier has said that sometimes a workaround may be that there's an affirmative order and notice saying you have 30 days to respond, and if you don't respond, then it's deemed to be consent. Is that an appropriate summary?
Yeah.
Okay.
It's not, I didn't want to just send them something general or just a plan, and the fact that they didn't object to being to be consented. If you send them a specific notice explaining what the circumstances are and that their failure to respond would be deemed to be their consent.
I'm curious
That's
to
about all we can do.
I'm curious to see what the next 60 days holds now that everybody just heard you say that. You may have just changed practice locally. Let's move on to the next slide if we
So
can.
it sounds like there's some interesting,
Anybody else but me. Not really even binding you.
just a suggestion of a way to work, and we've got a meeting coming up, so there's a couple of ways maybe that something productive can come out of this discussion. Okay, so next slide, dischargeability. And maybe what we'll do is we'll go through this rather quickly because we're running out of time, and maybe this is a little bit old hat. But, under that domestic relations, debts arising from divorce decrees are non-dischargeable in all chapters if they're domestic support obligations as defined under 101. And DSO is specifically defined, and that gets pulled into about 15 different provisions under the code, particularly 523A5, and then that pulls under all chapters. So a DSO is non-dischargeable across the board. The only type of divorce-related debt that is dischargeable is a non-DSO in a completed Chapter 13, and even that can be discharged if it's a hardship 13, and that's kind of like the...
Yeah, that's probably
that's
the
it in a
easiest rule.
nutshell.
Yeah, let's go to the next slide if we can. Of course, determining what something is, whether it's DSO or property division, is the trick. And I get this all the time. We're supposed to follow apparently federal divorce law, which doesn't exist. So you kind of look at the bankruptcy code, you kind of look at the Georgia code, you kind of look at the decree. And there's some cases, there's the Strickland case from 96 that says a domestic obligation can be deemed actually in the nature of support, even if it's not considered support under state law. So sometimes you get a better shot in front of the bankruptcy court than you do in the superior court. I always tell my clients, I'm from New York, I came down here, and I love Southern expressions. Usually there's a woodlands creature involved. But if you take a can of peas and you slap a corn label on it, what do you have? You don't magically have a can of corn. You have whatever you have. And divorce lawyers call me all the time, and I call this the hedging problem. Can we call it this unless this happens and then we want it to be that? Like, no, it is what it is at the time that you make it, and that's it. The changes that happen afterward don't change anything. And the truth is that there's a lot of horse trading going on in those back rooms of, I'll give you more property settlement if you agree to less child support. So if you look through all these cases, you'll see all kinds of disparity on what's considered a DSO and what's considered property settlement. Some of the factors are up there, which helps for alimony, and tax treatment is going to be the one that's going to disappear effective pretty much now.
There's certain ones that tend to be more controlling than others. There's a res judicata argument if somebody's taken it, as alimony and subtracted it or taken the tax deduction on their tax returns. Usually that's a pretty solid factor in that column. If it ends on death or remarriage, that's another really key factor. There are others that are more wishy-washy. And there's as many as 15 factors that the judges will look at. Some courts look at some of the factors, some courts look at other factors. And there's case law that's kind of all over the place, and I think one of the ways of looking at it, and Judge Bonifeld called me on this, do you have a case that really summarizes it this way? And the answer was no. But my summary was that, alimony really looks at things going forward. Does a party need this to live going forward? And property settlement really divides things as of that time and almost looks backwards. This is what the state of things is as of this point in time, and it just divides things up.
Yeah, I think that's a pretty good, basic, bad general thumb rule,
That was just
but better
just
than
a
nothing.
better thing. And do you have a case? No, actually, I don't have a case, but that's kind of, the down and dirty on it.
Let's go to the next slide. Let me skip this one. Some easy examples. Attorney's fees to opposing counsel in divorce cases are almost always domestic support obligations, guardian ad litem fees, and education expenses. Again, same kind of things that we'll see.
Let's flip to the next slide.
Yeah, let's go over to the next one. I don't know if I want to go into this.
Yeah, let's flip to the next slide. And on attorney's fees, it turns out there are about a dozen different state statutes on attorney's fees. And there's a memo that's flying around the Superior Court world on all the different bases for attorney's fees. And there's a case that I was involved in called In re Rackley, and Judge Massey entered this opinion that pulls in some of the state court attorney's fees provisions. And it actually matters what state court provision the Superior Court judge awarded the attorney's fees under. And if the attorney's fees were entered under a willful and malicious kind of 9/11, Rule 11 sanctions provision, then it's going to be harder to claim that those attorney's fees are a DSO. If the attorney's fees were awarded in a balancing the playing field, leveling the playing field type of provision, because a lot of the attorney's fees provisions under the state law go to giving the wife, it's usually the wife, it's rarely the husband, but just to be sexist here, to give the wife enough money to fund her divorce case or her child support case or to fund the child. A lot of the provisions go to leveling the playing field to give her the ability to fund her case. Then it's generally considered a DSO. And the attorney's fees statutes read that way. So if you delve into the underlying purpose of those fee awards, the willful and malicious statutes might actually require an A6 willful and malicious complaint, which you may or may not win.
However, don't think for a second, and this is the case where Ian got his butt kicked, that if something is a 9/15/14, which is the Rule 11 version in state court, clear obligation in a divorce case, that if you let the 60 days ride, you're good, because Judge Drake will quite clearly tell you that, nice try, Ian, it really doesn't matter because this came up in the context of a Chapter 7 anyway, so it's non-dischargeable.
And then you've also
Thought I had a good idea, Howard.
You might have a distinction on whether it was awarded to the lawyer or to the party. So there's some other things that go into attorney's fees.
All right, the preference problem. Let's stick on that slide for a second.
Go back.
Yep. Okay, so the preference problem. This is an area that just it bothers me personally. We all know that if somebody commits fraud, that's a problem. Great. If you've got a case where somebody just went through a legitimate divorce and two good lawyers sat in a back room and realized this is most likely what's going to happen in the divorce case, so we are going to sign a consent order, a settlement agreement in the divorce case. And then less than a year later, they file bankruptcy.
Or 2 years.
Or 2 years. You now have some of the trustees going after those transfers, saying that this is not reasonably equivalent value under 548 because the equities that the divorce court looks at is not reasonably equivalent value under the bankruptcy code. And here's where it really bothers me. And you said I think you said you've seen something that's changing this. If that case gets tried, I don't think a bankruptcy court touches that ever. But if it gets settled, they do. And it bothers me that now my advice to my domestic colleagues is maybe you should try this case. That seems backwards. And that's what's bothering me, is that I'm now looking at cases saying, well, maybe you should try it just to be safe. What are you seeing on this?
Well, I don't know that I agree that people would try it to be safe. I think there's still a predisposition to settling, but I do think that that if the case in the divorce world in Georgia, it's an equitable division world. It's not a community property world where everything's 50-50. So I think most of the time, and I describe myself as an armchair divorce lawyer based on Bruce's divorce practice, and 28 years of armchair divorce, that for the most part, divorce cases settle in the 40 to 60% range. And he has a ruler, and he says, there's a zone of reasonableness, and it goes, somewhere between the zone of reasonableness, which oftentimes is near that 50-50 mark. It's not that unusual for it is unusual for it to be that far beyond the 50-50 mark. When you have a case where it's really lopsided and a lot of the equity goes to one party and the debt goes to the other party, the trustees are all over it. And you've got to be.
And the problem is, it doesn't have to be fraud, because it could be that somebody's behavior during the divorce was so outrageous that might have been a very reasonable result in the divorce court.
And it might be that the quid pro quo is he got the business and she got all the equity in the house, and the trustee might not be factoring that in.
Right. All right, let's go to the next slide.
All right.
We'll try to wrap up with this one.
We're going to wrap up with this ethics question that we touched on a little bit earlier. And actually, Ian and I have been discussing this for 15 years, and I take the position that I don't want to represent two parties who are divorcing. that I see it as a conflict of interest, and he does it. He does it.
I've got a fairly lengthy, detailed, everybody reads, everybody waives, everybody has a chance to talk to their own counsel. But I get a lot of phone calls from the no asset spouses that have credit card debt in Cobb County in the mediation. And all of the lawyers and the mediator recognize that the problem here is that they can't handle the debt. There's nothing else to the case, but they can't handle the debt. So I get a lot of phone calls, will you represent them in a joint divorce? And if both lawyers and the mediator are recommending they come to me, and everybody's willing to sign off, and it is that circumstance, I'm willing to take that, and the Georgia rules seem to indicate that that's okay.
So we had this discussion. I actually spoke at a seminar with Judge Bonifel recently. We were discussing it, and the analysis was that so long as they retained their divorce counsel and they each had their separate divorce counsel, that it was probably okay. So then I went and I reached out to Paula Frederick at the State Bar, and I said, well, what do you think? And she said, so long as they have separate divorce counsel and a conflict, a head-on conflict doesn't arise, and they sign off on it, probably fine.
Chapter 7.
Chapter 7.
Do not do this in a Chapter 13, ever. I don't think there's any way you can get around the problem with
13 becomes problematic, and it also comes up, and it has come up. I mean, we've been involved in cases where it's come up where there's been a pending 13, and, financial matters are a reason for divorce, and they're in the middle of a 13, and they decide they want to get divorced in the middle of the 13. And then all of a sudden they're coming to you and they want to get divorced, and you've got the one lawyer who's been representing the couple for a while, and then what do you do? And that really starts to complicate things.
And I say ever, I actually do have one case that I think may have completed where I did continue. Everybody agreed. They only had a certain number of months left in the 13, that would be in everybody's best interest to finish that up. And I can't remember if we held off on the divorce or not. I can't remember what we did.
But I've seen
lots
where
of disclosure, lots of everybody signing everything.
There was one where you converted one, or one got converted.
Oh, you got to sever
and
everybody and convert. What a
a
disaster!
A mess.
So they're always
anyway,
lots of fun.
So last slide, which is the end. Oh.
Yeah. But the devil's in the details, and then last one is just contact information.
That's it.
So if anybody has questions, obviously always feel free to contact any of us, email, phone, whatever. Stop us in the hallway. We certainly don't claim to know everything or anything at times, but we're always happy to give what little piece of information we have for you.
Yes, well, a very big thank you to our presenters today. Again, this wonderful presentation will be available on the court's website under the Bench and Bar tab, so please be sure to review and share with others. And thank you all for spending your Wednesday lunch period. Again, if you seek one CLE hour, please be sure to see me. And thank you. We look forward to seeing you at our next presentation.